642-2016.
Yes, Mr. Agwala's matter.
Are they here? Sorry, sorry, gentlemen. Listen. Good evening. How are you? You are muted.
Good evening, my lord.
How are you?
Good evening, my lord.
Mr. Femi.
Yes, sir, my lord.
Yes, good evening. How are you?
Good evening, sir.
Thank you.
Very fine, sir.
Yes, sir. Listen.
My lord.
Yes, good evening.
Good evening. Thank you, my lord.
All the council here, it's like there are about 5. I can see Mr. Femi. The others have they joined?
My lord, Mr.
I can
Femi.
also see Mr. Omosu.
Yes, I can see Mr. Omosu. Yeah. Then the Mr. Okay. Adara Mewa from the ministry.
It's not here, my lord.
Oh, yes.
He has not joined.
Okay.
So, I think only 3
Hadia, okay, only 3 council. What do you do now? The matter for ruling, have the council in the matter joined? So I will just deliver the ruling and
I've not seen them, my lord.
But I don't know whether the link has been sent, because I sent the link to Joel.
Joel? Maybe I should call him and ask.
Yes, early in the afternoon, I sent the link to Joel. So
I don't know whether he has their number. I don't know whether he has their number, because if he has the number, it will be easier to forward it to them.
Okay.
Well, I will call him.
Call him and
with profound respect, my lord.
What do you do?
My lord, since the other council in the other matter they have not joined yet.
Yes.
We could just proceed with our own pending when they join, my lord.
But the other council too in your matter have not yet joined, the Adara Mewa and the.
Well, my lord, if we proceed like that, we may not even go on today.
Okay.
Because, yeah, some people may have problems joining.
Okay.
And I can see Jedida and Adam have connected
on my
to.
Yes, yes, sir. Jedida for the 4th defendant, sir.
Don't worry, I'll come to you, Mr. Adams.
Yes, sir.
I'll come to you.
At least, my lord, there are 4 councils in this matter now.
Yes. Yes.
Link.
Sorry, sir. I'll put no back. I'm not there for long. Hello, sir.
Yeah.
Yes, Haja.
Yes, my lord. My lord, I have no bad clue.
Can you call the case?
I don't have this thing with me. I'm all already.
Okay, so let me take your appearance. Mr. Femi.
Yes, sir. With due humility and profound respect to our lordship, Femi Aborisade. Femi Aborisade.
Your clients are not in court, huh?
No, they are not. I haven't seen them.
Claimants. It's okay.
I haven't seen them. but I sent the link to them. I haven't seen them. They may have that.
It's okay. It's okay. It's okay. Femi.
Appearing with me, my Lord.
Okay.
Appearing with me, my Lord.
Yes.
Is my
Yes.
letter.
Yes. Mr. Femi, I can hear you.
Odunayo Adeyinka. Odunayo Adeyinka. Yes, sir. May I spell the name? May I spell it? Name? Odunayo Adeyinka. Odunayo is spelled O-D-U-O-D-U-N. A-Y-O. Adeyinka is spelled, my Lord. A-D-E-Y-I-N-K-A.
Ateyinka.
Our husband. Yes, sir.
It's Ateyinka.
Yes, sir. Yes, sir.
For the claimants.
Yes, sir.
Mr. Femi. Okay.
Yes,
Yes,
sir.
any counsel for the second defendant?
My Lord, a counsel usually appears for first to third. I don't know whether they are online.
That is from the ministry.
Counsel for first to third.
Yes.
Adaramewa.
Yes, Adaramia from the ministry.
Yes, sir. He appears for
Okay.
the
But maybe he's not around. So Mr. BJ Adams.
Yes, my Lord, sir.
Is BJ.
This is my Lord, sir. Yes, sir.
BJ Adams.
Yes,
for the
fourth defendant, sir.
Okay.
The name is not pronounced.
Yes, Mr. KS Omosue.
Hey, please, my Lord, KS Omosiwe. My Lord,
Yes.
I appear for the fifth defendant, my Lord, the fifth defendant.
Okay. Thank you. Yes.
With profound respect, my Lord.
Yes.
E.Y. Kura, my Lord.
Mr. Adams.
Yes, my Lord, sir.
It's okay. It's okay. Just mute yourself. Yes.
E.Y.
Kura.
E.Y. Kura, together with my learned brothers, H.U.L. Yakub.
Okay.
SN, we appear for the seventh defendant applicant.
Okay.
Yes, my Lord.
Yes. Yes, Lana.
Yeah, my Lord, the matter was adjourned to today to enable us move our applications, which we filed on the 15th. Yes, my Lord.
Yes.
And we are ready to move same. My learned friend, Mr. Femi Aborishade, didn't receive any counter affidavit from them. Neither was their written address.
It's an application for amendment.
Yes, my Lord. My Lord, the first application is, there are two applications.
Okay.
The first one is for extension of time to respond on point of law to his own, to my friends, my learned friends' written address, opposing our. And then the second one, my Lord, is for the amendment.
Okay, so which one do you want to take first?
May we, my Lord, with my Lord's kind permission and the convenience of my learned friends, may we move the one for extension of time first?
It was filed when?
On the 19th of May, my Lord.
Okay, 19th of May.
2022. And it's dated 17th of May.
Okay, but the other one too for amendment was also filed on
the same day. They were filed the same day, man.
Okay.
Robinson.
Okay. Mr. Femi, no objection to the application, ba?
My lord, I have an objection.
Did you file a
Because-
count?
No, I didn't. But if I explain myself, the court may also easily agree. Even the applicant may also brought a motion to amend processes.
I can't
The
hear.
processes that the applicant seeks to amend includes their counter claim.
No.
So when they amend their counter claim and they are now regularizing their reply to what we already wrote, to what they are going to substitute for an amended counter claim, that will serve no purpose, because we are still going to react to their amended counter claim.
With profound respect, my lord.
Yes.
My lord, the changes we made are only cosmetic. They did not affect the substance of our address. Our address remains the same. Nothing was changed.
That's the changes in the reply to the.
No, the change we made was merely to form. It was actually not that we didn't touch the address. My friend Femi. If you had looked at the address we filed and the one we are amending, you find out that the difference is just cosmetic. There is no substance. We did not add new cases. We did not add anything substantial. Your address you could look at it. If you look at it well, you may find out that you don't need to do anything.
You have an amended written address. You have an amended.
Yeah.
If you look at the prayers to amend, they include to amend counter affidavit to the claimant's suit, to amend counter claim, and to amend written address.
Yes.
Now you have filed a motion to regularize your reply to our written address to your counter claim. Yet you are amending your counter claim, to which you are still about to react.
Hello? I don't know whether Femi can hear me now.
Let us see if I can hear you.
Sorry, Mr. Peters. Mr. Peters, yes. Can you mute yourself? Mr. Peters, mute yourself, please.
I'm sorry, my lord.
Thank you. My lord, the point I'm making is that
yes,
the amendment we are making are actually not substantial. In fact, it was more as to form. If my lord looks at the previous counter affidavit, we separated it from the. You find out that we separated it from the counter claim, but now they flow together. So because we have to amend that, the amendment will not affect whatever you have written. If you look at it, you need to look at it again, because if you had looked at it, Femi, you may not be responding in this manner. I don't know whether Femi is getting what the point I'm making. That's why you needed, in fact, that was why we took an adjournment to enable you study what we have filed and see whether there is the need for you to respond or not. But you did not respond. If you had responded, maybe you would have been given an opportunity to respond.
As far as your motion to amend is concerned, we are
Yes.
not objecting.
Okay,
But
so
in the motion
okay.
to amend, you have
No,
have your
Mr.
counter
Femi.
without- amended counter without it.
Sorry,
You have your
Mr.
amended
Femi.
counter claim. You have your amended
Mr. Femi.
billing address.
Mr.
Then
Femi.
you want to regularize.
Mr. Femi.
Yes, sir.
We're talking about the seventh defendant's application to extend time to file its reply to your address in response to his counterclaim.
Yes, sir.
It's a reply to your address, to your counter to his
Yes, sir.
counterclaim. So
Yes, sir.
are you objecting to that application to extend time to file his
We
reply?
object, my lord, because the applicant also has one of the processes to amend is counter claim. So we
Yes,
are
but-
bound to. They
Yes,
have an amended counter claim.
Yes, but you can still extend time to, since you have joined issues with him with regards to the earlier counterclaim. You have joined issues with him with regards to the earlier counterclaim.
Oh, my lord, the question is how many replies would they now file?
No,
Because when they file their amended counter claim, they
Oh,
are bound
okay.
to react to it.
Okay, what I want to ask is that do you intend to file, a response, a reply to his amended counterclaim? Do you intend to do anything? Do you intend to react to that? Did you get my point? Mr.
Definitely,
Femi.
my lord.
Mr.
Definitely, my
Femi.
lord.
My lord,
Yes,
You
my
have
lord,
seen his counterclaim. Is that, Mr. Femi,
Yes, sir.
you have read his amended counterclaim. Is that
Yes,
so?
sir. Yes, sir.
And do you intend to react to it?
Yes, sir.
okay.
Eh?
Yes, sir. We're going to react to it, sir.
Even if you intend to react to it, you can still extend time to file his reply. If you react to the,
Exactly. So they will be having how
hold
many
on,
replies to their counterclaim? That is the question,
Mr.
my
Femi,
lord. How
hold
many
on.
replies do they have?
Mr. Femi, hold on. Even
Yes,
if
sir.
you react to his amended counterclaim, he can
Yes, sir.
still file a reply and withdraw the earlier one.
Exactly.
As the court is-
But if you're not willing to react to his amended counterclaim, then he will allow that his reply. You
No, we
understand
are
that,
going to, we are
that he
going
wants to
withdraw
regularize
because
today.
they have amended it. So we have to
They have-
react to the amended counterclaim.
And what he's now telling you is that it doesn't touch the substance, that's the amendment. And even if it does, you can still file your response or reaction to his amended counterclaim. And if he has anything to file again as per reply, he can file, withdraw the earlier one, and go on with with his extant reply.
As the court pleases.
As court pleases.
So it's a simple.
My lord, sir. My lord, sir, I want
Yes.
to beg of you, my lord, sir. My lord, sir, I'm still on the road and my battery is 3%, sir. I might go off from this proceedings, sir.
So you don't have any objection to the
No, my
applications
lord.
filed, but
No,
no
my
objection.
lord. No objection, my lord.
It's okay.
So I will just
It's okay.
request for the adjournment. sir.
Okay.
I'm most grateful, sir.
So Mr. Femi, no objection. For now.
No objection. No objection, my lord.
Mr. Omosue,
My lord, I do not object, my lord. I have no objection, my lord.
thank you.
Thank you, my lord.
Thank you. Solano SCN, your application is filed and dated on the.
It's filed, my lord, it's dated 17th of May and filed on the 19th of May, my lord, 2022.
Okay.
And since my learned friends, my lord, are not objecting to the grant of this application,
Okay.
may I move in terms of the application while urging my lord to grant same?
Okay.
I must oblige, my lord.
Thank you. So Lara is saying,
My lord,
it's a reply on points of law to the claimant's counter affidavit to your counter claim.
yes, my lord. We filed it, my lord. We also filed it on the same date, 19th of May,
Yes.
2020.
Yeah, what I'm trying to say, there is a reply to the
To
claimant's
his written
counter affidavit.
Yes, and his written
Claimant's counter
address,
affidavit to
because
your counter claim. Okay.
yes, my lord.
Okay.
My lord, sir.
Yes. Yes.
The reply on point of law is in reaction to our written address to their counter claim.
Okay, you didn't file a counter affidavit to the counter claim.
No, we didn't file a counter affidavit, my lord.
No, I'm talking to Mr. Femi. Well, Mr. Kura, when you file your counter claim, what did Mr. Femi file? Is it a counter affidavit?
My lord, he filed a counter claim and a written address. Counter affidavit to the
So what I just want to call it reply on points of law to the claimant's counter affidavit to the seventh defendant counter claim.
Written address.
Written address, but the written address is in support of the counter claim.
Yes,
we have many written addresses.
No, written address in reply to his own written address opposing the counter.
Your counter claim. Look at
your counter claim
of your reply on point of law.
Yes, reply on point of law to your written address opposing our counter claim.
It's okay.
Yes, my lord.
So seventh defendant's application for extension of time to file its reply to the claimant's counter affidavit stroke written address to the seventh defendant's counter claim dated 17th of May 2022, but filed on the 19th of May 2022 is granted as prayed.
As court pleases.
The court pleases.
That is
my lord. My lord, our second motion. Yes, my lord. Our second motion, my lord, is also dated 17 May 2022 and filed on the 19th of May 2022.
It's for amendment. It is for
Yes, my lord.
amendment
It's for amendment.
of your counterclaim.
Yes, my lord.
No, amendment of your
Of our
counterclaim.
counterclaim, yes, and counterclaim as well as the written address.
Okay.
Yes.
So you have.
It is more than that. I pray the court to ask the legacy to read their prayer number 1. They are also amending their account affidavit.
No. There are three processes, Mr. Femi.
We have processes in one.
3 processes.
Yes, 3 processes. The amended counter affidavit.
Exactly.
The amended counterclaim, and amended written address.
Yes, exactly.
Yes,
written address.
Yes, my lord, written address.
Yes. So, Mr. Femi, any issue with the application?
My lord, we have no objection, but we shall be asking for time to file consequential processes in response to the amended processes.
Yes.
And also, my lord, we pray the honorable court to award costs against the 7th dependent, because they have put us to we have to expend resources to refile our processes, which we had filed earlier, to their earlier processes. We still have to react to their amended processes. So we pray the court to award a cost of 50,000 naira against the 7 dependent in view of the costs that we are going to expend. Much obliged, sir. And this is covered, my lord, under Order 26, Rule 3. Amendment may be granted conditioned upon terms, including costs. So our prayer is predicated under Order 26, Rule 3 of the rules governing the court.
Mr. Omosue, no objection.
My lord, I am not objecting, and I do
you.
not see the basis for cost, and so will not be venturing to ask for cost, my lord.
Okay, thank you.
lord, since my learned friends are not opposing the application,
Yes.
may I move in terms of the application, my lord?
Okay.
While urging my lord.
Okay.
My lord has to call. Mr. Femi is a very big counsel, a very senior member of the bar who I'm surprised that he'll be asking to be given 50,000 when he's sitting in the comfort of his office in Ibadan. When he's sitting in the comfort of this city, if he was,
it is for the processes that we have to begin and file in Lagos.
Oh, but he said he's going to file. He said he's going to file further processes. Mr. Kura.
My lord, we could give him. My lord, we could give him 5,000 naira. He's not to file counter and
Okay. Mr. Femi, are you considering to the 5,000 naira, or I should just add it to 10, 15 or 20?
No,
Mr. Femi.
My lord, we cannot consider because it is not realistic. We have, my lord, we are not considering. We have established the basis, the filing phase, the surveys on all the dependents, the transportation from Ibadan to Lagos, hotel accommodation.
But
my lord,
we cannot.
Do you need to file any further?
Come to Ibadan and sleep in the hotel to file processes.
Mr. Femi, are you in Lagos or you are in Ibadan?
We are in Ibadan, my lord.
Eh?
We are based in Ibadan, my lord.
So what hotel accommodation are you talking about?
What is this living
we cannot
Lagos
for? One day, my lord, and file in Lagos. File anytime we have to appear.
Oh, okay,
we have
Mr. Femi.
A day before because of
Mr. Femi.
Yes, sir.
I understand. Sir. Okay, having do you need to file any further any consequential amendment? It's like Mr. Kura is saying that the amended contract claim.
That is what he's saying. I have gone through. There's a need, my lord,
to
react to the amended processes. Because if actually my lord did not give them this opportunity, they use the opportunity my lord gave them to repackage their processes. So we have to react.
Okay. Okay.
They are taking advantage of having read our reaction to their processes. That is what informed their amendment.
Okay.
So at least we haven't explained that much, my lord. We can add 5,000 naira to make 10. Mr. Femi doesn't need to sleep in Lagos to file processes. Can just rush to Lagos from Ibadan, file and go back to them. And there's even a train there now, my lord, servicing Lagos and Ibadan.
We know how many hours.
Okay, it's okay.
When we sleep in Lagos, how many hours to arrive in court? How many hours? If you don't wake up by 3 a.m., we can't get to court.
Okay, it's okay. So serving defendant's application to amend its counter affidavit to the claimant's suit, counterclaim, a written address, dated 17th of May 2022, but filed on the 19th of May 2022, is granted as spread. Meanwhile, 20,000 naira cost is awarded to the claimant against the 7th defendant. 20.
As court pleases. As the court pleases.
As court pleases. How much, my lord? How much, my
20,000.
I didn't get the amount of court. 20.
20,000.
Yeah, my lord, even though this observation may be belated, I wish to inform the court. I said, even though this observation may be belated, I wish to inform the court that I didn't receive any atom of information as regards the sitting today, my lord. Even though the registrar promised at the last adjourned date, and I furnished my email address, it was actually cancelled to the fourth defendant who sent a text message to me, furnishing me with details of the proceedings today. So I may want to assume that other counsel who are not
yes, we're not also served.
Yes, my lord, I have the same problem with Mr. Omosiwe.
Okay.
In fact, I kept pestering the registrar. Are we really sitting on Zoom? I've not seen the Zoom, the ID, or the passcode. So it was after 2 p.m. this afternoon that it was forwarded to me. In fact, we had assumed we were supposed to go back to Kaduna. We are in Abuja actually. We were supposed to go back, but I said I don't want them to do the matter to start while I'm on transit because I cannot pass along because of the insecurity issue on the road.
I'm actually in my car right now because I'm in a conference.
I can see Mr. Moses
in my car.
Yes. I think next time if we will sit on Zoom, they should say that a day or two before.
Exactly. Yes. It's okay. It's okay. We're so sorry about that. It's our IT person that didn't send the Zoom link earlier. So sorry.
Thank you, my lord. Thank you, my lord.
I also saw one process filed by the claimant. Further affidavit in support of the claimant's originating summons and in opposition to the fifth defendant's counter affidavit filed on the 23rd of May.
My lord.
Yes.
My lord, we didn't file any. My lord, we reacted within time, sir.
No, I know.
There's no need for us to regularize.
I know. No, what I'm trying to say is that it's a process that was filed on the 23rd of May. You know, the last adjourned date was the 19th of May.
Yes, sir.
So,
yes, sir.
So this year further affidavit was filed on the 23rd of May. So I don't know whether Mr. Akura, Mr. Omosiwe, have received the process.
Yes, my lord, I was served on Saturday. That's the 4th of June. In fact, I just asked the bailiff to scan it to my email, and he did.
Okay. Sorry, please, who are you, please?
It appeared that the claimant have taken over proceedings, my lord.
Yes, who are you, please? Are you the claimant? Who are you, please? The person using Infinix. Who are you?
Already know.
Can you mute yourself, please? Mute yourself, please. Please, who are you? Mr. Femi, what do you do now? Yes, Mr. Femi.
Yes, sir.
Yes, what do you do now?
We have served the defendant, unless they want to, but they don't also have any right to reply to it. It's our further affidavit.
No, what I'm saying is that, what do we do next?
Oh, my lord, it's to adjourn for hearing, my lord.
It's like you said you are going to.
Yes, we are
going to react to.
We are going to file consequential processes. So the date of adjournment may take care of the period within which we are to react, my lord. We will do so very promptly, depending, subject to the convenience of the court.
My lord, if they react and there are new things in it, we may need to refile our reply on point of law, depending on their reaction.
A reply to what? But you said your amended contract claim is not substantially different.
Yes, my lord. My lord, I'm assuming that if he adds anything to what we have already, we may need to add something in our reply.
You can,
and then we draw the other one.
You can still file in the interim now.
Yes, my lord.
You can file in the interim. Yes.
Yes. If there's anything, we can withdraw that one and file another one. I will file it promptly.
Okay.
Yes, sir. The adjourned date, my lord, may take care of the periods within which they may also file any reply, my lord.
Okay, let me ask you that.
Taking care of
let
this.
Me ask whether the registrar is still around. The registrar, Hajia, she's off, but
she told the court that she had no battery, my lord.
I want her to give us
she had no battery.
Should I adjourn after vacation?
After vacation, that will be a positive, my lord.
Yes, sir.
To take care of this exigency, my lord.
Okay.
Yes, my lord.
Yes, sir.
We are going to resume. We are going to resume on the.
Yes. Be suitable, my lord.
Huh? So should we adjourn it now, or we should?
Yes, sir.
Yes.
My lord, I think it's better we get a date now.
Okay.
Yes, sir.
Let us plan our other matters.
Okay, so should we are going to resume on the 29th of September. Yes, 29th. So maybe we should get a date around
October or November.
Yes, October or November.
Yes, my lord.
Early October, my lord.
But let me call the registrar so that she will. How are you?
Hi, sir.
We want a date after vacation.
A date after vacation.
Yes, for hearing.
Yes.
So which date are you giving us? Okay. Huh?
What of December
14th? Aja, December 14th is.
That is fine, my lord. May we suggest November?
Which date?
November, because my October actually will have taken dates, my lord.
I know the our diary is already chalked up. The
I know
October, November. Aja is for hearing of the substantive case. And although this case may, may appear to be a difficult one.
It's also a matter commenced by originating summons, my lord.
Yes, but the problem is that it may appear to be a difficult one because I'm going to determine your substantive matter, then the seventh defendant's counterclaim.
Yes, sir.
And I think there are also some other pending POs. Is that so?
No, sir. They have.
Okay, been withdrawn.
All the POs have been withdrawn, my lord.
No POs any longer.
Okay, so I'm now going to determine the substantive matter and the counterclaim of the seventh defendant.
Yes,
exactly,
my lord.
As the court, please.
And then the other further things that you filed. Okay.
And
So
even
Hajia,
the ones that are yet to be filed, my lord.
eh?
Even the ones that my friend
No, they are
Femi,
all part of the substantive
You see?
matter. They are all
see?
part of the substantive matter.
yeah, they are all part of the substantive matter.
So Hajia, which date are you suggesting? That 14th of December, it will not be okay. December, January, February, March. Then the ruling will be sometimes in March.
The 14th of December is convenient, my lord.
Eh?
It's convenient, my lord. 14 December is a Wednesday. It's convenient, my lord.
Convenient for me, my lord.
Yes, Mr. Femi.
Well, my lord, it's convenient, but my clients are sovereign. Or they place all their hope on this case, my lord.
Your clients are.
They are sovereign.
Okay.
Because bodies of registered under part C have taken over their job. They don't allow them to operate.
Mr. Femi, even on the 14th, it's not a judgment will delay by.
I know. That is why I'm saying that date is no convenient in my diary, but it appears too far. If it's possible, my lord, if in November 10th is possible, my lord, we'll appreciate it.
This matter was filed.
My
Mr. Femi,
for the claimant
Mr. Femi,
is
this matter was filed.
already shown. This is the matter.
Yes, sir. Yes, sir.
It was filed on the. Okay. It was filed.
2021.
Okay, last year.
It was late
Yes,
last
sir.
year.
Yes, 24th of August.
Yes.
Yes, sir.
It's not.
So it's almost 1 year now, my lord. And the defendants, they caused it. They are just filing their process.
Maybe you are already blaming everybody
my
now.
lord. It is deliberate. They are working together to prolong this matter.
This one is the court that says it.
My lord, the date is was suggested by.
It would appear that the counsel to the claimant already is already in this matter.
Hajia, Ristra, that 14th of December is what?
It's a Wednesday, my lord.
And you're sure that the court is going to sit? No, because of the Christmas and why don't you?
No, the vacation, my lord, the Christmas vacation is after those dates.
No, but let's still.
It's after those dates.
If there's any other date before the 14th, please give us, like 7th of December, or I mean the first week.
Okay, 7th of December.
Yes, you know that time people are rushing to run away from Lagos and yes.
And on the 7th of December is not convenient for me. 8th of December is convenient. 6th of December is convenient. 6th is convenient.
Okay.
8th is convenient.
My
but
lord,
the 7th is not.
My lord, that
so
week
just,
hello, my lord. My lord, that week is not convenient. That suggests the 12th or 13th.
I don't want us to get to the second week of that second week. Hajia.
What of the 8th, my lord?
Oh, Mr. Most is saying that. Okay, it's okay.
Yes, my lord.
Hajia is 8th of December, okay. Mr. Femi, 8th of December.
Yes, sir.
It's okay?
7.
8.
No, 8.
8th of December is okay, my lord.
Okay.
It's okay, my lord.
Thank you.
And the letter said they have several lawyers in his chambers. In fact, there are two powerful letter six. They cannot complain of. They have very senior lawyers in their chambers who can represent them adequately.
Femi, no problem. If I'm not able to come, somebody will come.
So 6th December then it's okay.
No, sir, no, 8 is convenient. We have about 3 matters on that date.
But you have not less than 12 senior lawyers in your chambers. Let us see.
Well, everybody has his own assignment.
So may we know the convenience of the court, my lord?
Okay, Mr. Adams, are you here? Mr. Adams.
He already excused himself that his battery was going flat.
That his battery was down.
Yeah, the battery was down.
Yeah, but I can still see his name there. Okay, false.
So that means he's still around, only not paying attention.
It's okay. So cases are adjourned to the 8th of December 2022 for hearing. Here notice shall be issued and served on the 1st to 3rd, 4th, and 6th defendants.
That's God pleasing.
Hello, sir. I was trying to check my place. I was not paying attention. I was trying to check my phone, but I'm following the.
Mr. Adams.
Yes. Sir.
Can you hear me?
Yes, I can hear you, sir.
The matter was adjourned to the 8th of December.
Yes, I'm following. It's just I was charging the phone in the bus, so I couldn't have access to it. I'm paying much attention, sir. Contrary to what Mr. Femi said, sir.
Okay, thank you. So, thank you, Lanes and Mr. Femi.
Most lights, my lord. We are most
Mr. Onesue, thank you so much.
Yes, my lord. Thank you, my lord. Thank you, my lord.
Thank you. Bye-bye.
Yes, sir.
Aja, are you still with us? It's okay. We have adjourned it. The next matter, Mr. Peters. Mr. Peters.
With due respect, my lord. Lord, with due respect, my lord.
Yes, I can hear you, Mr. Peters.
Peters Agbola is my name, sir. My lord, I appear for the claimant.
Okay. Peters.
Agbola, my lord.
Okay, Agbola. Yes, any person for the defendant, Ms. Ramatu, maybe she wasn't served. Okay, so let me just deliver my ruling.
Let's go, places.
So by motion and notice dated on 7th of February 2018, but filed on 28th February 2018, the claimant applicant pressed the court for the following reliefs. Number one, an order of this court compelling the defendant to produce on oath the following documents which are under their possession, custody, power, and control for the use of the claimant in the instant proceedings. Defendant's car logbook of the Toyota bus with registration number GGE 256PH used by the claimant on the 31st day of January 2016 and 1st day of February 2016. The documents for the schedule of persons entrance bookings ordered and made by the first defendant with respect to the meeting held on the 1st of February 2016 at Golden Tulip Hotel, Ikeja. Number C, the defendant's account book showing entry payments made by the defendant to Golden Tulip Hotel Airport Road, Ikeja, Lagos, for the purpose of the meeting held on the first day of February 2016. Number two, and further orders of this honorable may deem fit to make in the circumstances of this case. The grounds upon which the application is brought are as follows. Number one, in paragraph 22 of the statement of fact dated 19th day of October 2016, claimant avers that he used the defendant's Toyota bus with registration number GGE256BH used by the claimant on the first day of January 2016 and first day of February 2016. The fact was denied in paragraph 6 of the defendant's amended statement of defense dated on the 8th day of November 2017. Number 2, in paragraphs 19, 23, 31, 32, 33 of the statement of fact dated 19th day of October 2016, the claimant avers that he was logged into Golden Tulip Hotel, Airport Road, Ikeja, Lagos, and the payment for the accommodation was made by the defendant. Fact was denied by the defendant in paragraphs 6 and 9 of the defendant's amended statement of defense dated the 28th day of November 2017. It is the defendants who have under their possession, custody, power, and control the car logbook for the Toyota bus with registration number GGE256BH used by the claimant on the first day of January 2016 and first day of February 2016. Number 4, it is also the defendants who have under their possession, custody, power, and control evidence of the payment made for their guest lodged at Golden Tulip Hotel, Ikeja, for the defendants meeting held on the first day of January 2016 and 1st February 2016. Number 5, the documents sought herein to be produced by the defendants will help this court in coming to reasonable resolution issues by the parties and will assist this court in the just determination of disputes. Number 6, it's in the interest of justice to grant this application. Counsel the claimant filed a 7-paragraph affidavit in support of his application. A written address in support of the application was also filed wherein learned counsel raised a loan issue for termination to it. Whether this court has requisite power to grant the relief sought in view of the fact contained in the affidavit and the pleadings before this court, in arriving at the just and judicial determination of the issues which have been joined by parties. Learned counsel submitted that by virtue of Order 43, Rule 3 of the rules of this honorable court, this court is empowered to compel a party upon the application of the other party to produce a document in its possession, custody, power, or control for the use of the applicant in court. Counsel also relied on Order 43, Rule 6 and 12 of the rules of this honorable court and Section 167D of the Evidence Act. Counsel submitted that the grant of the instant application is aimed at assisting the court in arriving at a just determination of the issues which are the subject of the application. The submission of a counsel that even though the court is enjoined by virtue of Order 43, Rule 12 to raise presumption and withholding evidence against a party who has refused to produce the documents after having been compelled to do so, the appellate courts have elevated the sanctions so that to that of disobedience to the order of the court for which a party could be committed to prison. Citing the case of Olu, Sanya, and Osibamo, counsel submitted that though it is not the duty of court to get evidence for a party, but the procedure under the rules of court is to enable this court come to the assistance of the party who requests document to compel the other party to produce the said document so that it can be made available for the court's use. Counsel further submitted that the court can exercise its discretionary power, which should be used judicially and judiciously as empowered by virtue of Order 43, Rule 8 of the rules of this honorable court to grant the application. Counsel further submitted that where issues have been joined, it is in the interest of justice that application is granted to enable the court arrive at a just decision of the issues. This application, the defendant filed a 9-paragraph affidavit on the 6th of March 2018. A written address in support of the affidavit was also filed. The defendant in the written address raised a sole issue for determination to it. Without having regard to the facts and circumstances of this case, the claimant applicant has made out a case warranting the grant of the prayer sought for on the motion paper. Also, the defendant submitted, although a party can apply to court to compel an adverse party to produce documents on off, but that such order can only be made if it is established that the documents listed in the notice to produce and the custody or possession of the adverse party. that a party who is not in a position to produce the documents listed in the notice to produce may file an affidavit stating so. Counsel cited whether for 3 Rule 10 of the rules of this honorable court. Counsel referred to paragraph 4 of the defendant's counter affidavit, which states that the documents which the claimant requested from the defendant are not in their custody and therefore not in position to produce such documents. It was also averred in paragraphs 6 and 8 of the statement of defense that the defendant did not make bookings for the claimant or any other person as regards the meeting held on the 1st of February 2016 at Golden Tulip Hotel. Counsel relied on the following cases: Idigbe and Commissioner of Police, Buhari and Obasanjo. And the counsel also submitted that presumption of withholding evidence can only be invoked by virtue of order for 3 Rule 12 of the rules of this court if it's established that the documents are in possession of the defendant. It is a submission of counsel that from the facts pleaded and the relief sought has no connection whatsoever with the documents listed on the notice to produce. Counsel argued that the claimant's case before the court is that the termination of his employment with the first defendant is unlawful and traceable to the claimant's refusal to submit to the sexual harassment of the second defendant and the whistleblowing of the criminal activities of the second defendant by the claimant. Counsel further argued that the documents listed to be produced on the motion will not assist the court to effectively determine the issue before the court, and as such, the application should be dismissed with cost against the claimant. In his reply, claimants filed a 20-paragraph further affidavit on the 13th day of March 2018 in reaction to the defendant's counter affidavit. A reply address was also filed in support of the further affidavit, wherein counsel for the claimant yet again raised another issue for determination to it. And I quote, whether having regard to the facts and circumstances of this case, the claimant applicant has made out a case warranting the grant of the praise sought for on the motion paper. The Honorable Counsel referred to order for 3 Rule 3 of the rules of this court and the case of Achihulu and Anyatonhu to submit that this court is empowered to compel a party upon the application of the other to produce a document in its possession for use of the applicant in court, and the claimant has complied with the rules of this court. Counsel finally urged the court to grant claimant's application. I have gone through the processes filed by the parties and considered their arguments and submissions. And in determining this application, I wish to refer to order for 3 Rules 2, 3, 12, and 13 of the rules of this honorable court. which state as follows. Rule 2 says, and I quote, where a party files a matter and serves the process on the other party, but discover that the other party needs to make discovery or inspection or disclosure of documents or recording on an electronic device such as computer hard disk, external hard drive, flash drive, or compact disc, referred to as CD, tape, memory card, electronic camera and phone, etc., all of which are in this order referred to as electronic device, which are in possession, custody, power, or control of the other party. The first party may apply to the other party to make available and or produce a certified true copy of the documents or electronic copies of the party for inspection or use at the trial. Rule 3 says, and I quote, where the party in possession, custody, power, or control of the document or recording on an electronic device referred to in Rule 1 and 2 of this order refuses or makes it impossible for the party seeking for recovery or production or inspection or otherwise to achieve those aims, the party seeking may apply by motion and notice for an order of the court compelling the other party to produce the document or the recording on an electronic device, etc., in the other party's possession, custody, power, or control. 12, why a party in possession, custody, power, and all of the document or a recording on an electronic device refuses, fails, or neglects to comply with the order of the court may presume that if produced or made available by the party, the document or the recording on an electronic device will be unfavorable to the party's case. Rule 13, further provisions of order of rules 1 and 2 of this order, while the party on whom a request for discovery, inspection, or production was made refuses or fails to comply with the request, the court may allow the party making the request to use the copies of the document or recording on an electronic device in the requesting party's possession at the trial, and the party refusing or failing to make such documents available shall not have the right to object to the admissibility of any available copy tendered and used by the seeking party on court. I need to observe that the defendant in their counter affidavit, and of course in their statement of defense, have stated that they are not in possession of the documents sought to be produced. My understanding of the above provisions of our rules and the provisions of the Evidence Act is that while a party on whom a notice to produce is served fails to produce the documents, then that does not necessarily mitigate the burden of proof on the seeking party, as the law is that he is to succeed on the strength of his case. Thus, he is entitled to produce secondary evidence of the documents which the respondent failed to produce after a notice to produce under Section 89 of the Evidence Act was served. See the case of Idigbe and MTN. Similarly, apart from the entitlement of the seeking party to adduce secondary evidence of the documents by virtue of Section 98 of the Evidence Act, the non-response to a notice to produce will also cause the court to invoke the presumption of withholding of evidence under Section 149D of the Evidence Act against the defaulting party. I note that parties have joined issues in their pleadings with regards to the documents sought to be produced. Whilst the claimant alleges that the documents are in possession of the defendant, but the defendant contends that they are not in possession of same. Bearing that in mind, I think it should not be appropriate for the court to make any pronouncement at this stage that should prejudice the substantive case. I believe that the claimant has done his bit by requesting the defendant to produce the documents so that the failure to produce will entitle him to either tender the secondary evidence of the document or ask the court to invoke the presumption of withholding evidence against the defendant. In the light of the above, I'm not persuaded that the claimant's application has merit and is accordingly dismissed.
Hello, thank you, my lord. I'm grateful. Thank you, sir.
Thank you, Mr. Peter. Just since you have put them on notice, their failure to produce, will make the court to presume that it's unfavorable to them.
Yes, my lord. I like to learn, and my lord can just guide me. My understanding, my lord, is that for a party who wants to tender a secondary evidence,
yes,
and has given notice to produce,
yes,
that will only be when that party is in possession of the secondary evidence.
Yes,
yes. But in this case, my lord, without prejudging the mind of the court.
Okay, if you are not in possession of the secondary evidence, and it is proved in the substantive case that yes, of course, those documents should have been with the defendant, then the court is going to presume that their failure to bring them, is favorable to them, even though you don't have the secondary evidence. But if you be able to prove in the course of the trial that yes, these documents should have been with the defendant, and they failed to produce, then the court will presume that, then that's why they are trying to confuse.
My lord, I will leave it like that. I appreciate the point being made.
Let me call her.
I don't know when we can come back.
Yes, let me call her so that she give us a date. Yes, Haja, we need a date in this case, Mr. Hassan's case, 6/4/2016. Okay. Mr. Peters, it should be a date for what? We are joining for what?
Trial, my lord.
For trial. Date for trial. Okay, date for trial. Eh? 8th of December. Can't you have any other date, any other earlier date? Okay. Mr. Peters, she is suggesting the 8th. Yes.
8th December. My Lord, is 8th December is 8th December is a Sunday.
How do I say Sunday? Eh? You said what? Okay, Mr. Peters, she said it's a Thursday.
December.
Yes, you said.
Okay, yes, I've seen it, my Lord. I'm sorry. I'm using my app and my hand went to January. I'm sorry, my Lord.
Okay, okay.
Yes, it's correct. My Lord is convenient. 8th December.
Okay. Okay, Ajay, 8th of December. Okay, thank you. Okay.
Thank you, my Lord. I wish my Lord a restful vacation.
Thank you, Mr. Peters.
Thank you,
Thank you. The matters are until the 8th of December 2022 for trial. Here notice shall be issued and served on the defendant. And in the absence of any other thing, Mr. Peters, I wish you a very good evening.
Thank you, my Lord. Thank you, my Lord.
Have a nice weekend. Thank you.
And you too, sir. And you too, my Lord. And you too, my Lord.
Thank you.
Yes, sir. Yes, sir. Address